Paul? Yes. I just got to the study room and it's 124. And I was just kind of going through some documents. Yes. Now, when I was looking at the state of Washington's professional person, yeah. Phyllis, yeah. I just want to make sure, as that psychiatrist, yes. Now, when we were talking about the discussion you were having with Jack Range, the attorney, where I was not present, yeah. While you were having that discussion that happened to be against the law because I have the right to be present at all times, yes. You specifically said that Jack was there to advise me if I should or should not say anything. Yeah. Now, the evaluator, yeah. You're not an attorney. You're a professional person from the state of Washington. Yes. And you're not an expert on the law. You're not in a bar association. Yeah. Therefore, I needed to clarify some of Mr. Budnick's statements. Yeah. Now, Mr. Range informed me that the violation of the Women's Act did not apply in this case. He also stated that protection orders are occasionally served before the court has convened, and we talked about the permanent protection order. Yes. And that, yes, occasionally they are served before there's an actual court hearing. But the Violence Against Women's Act Prosecutor's Guide makes it abundantly clear, yes, that before a permanent protection order can be issued, right, that the respondent has to have notice and opportunity to be heard. Now, I know Brent Baisden, Superior Court judge, that Justice Owens just swore in the last 2 to 3 months. Yeah. His thought was that when you require mental health evaluation, you have no rights as a parent. But you can always give the person notice and the opportunity to be heard so that the Superior Court judge can tell them, I want you to get a mental health evaluation. Now, there's this idea, yes, let's say you issue a protection order. Seems self-explanatory, doesn't it? Yes. That when you put in number 9, mental health evaluation and treatment if recommended, and I'm supposedly some delusional, schizophrenic, bipolar individual, yes, and you don't take the time to actually inform the respondent of what the court wants, yes, because you don't enforce the laws. You would think that any judge, any court commissioner, any of them, yes, would much rather be able to speak to the individual known as the respondent, yes, so as to tell them what they want. Oh, I spit on the webcam. Excuse me. Now, these idiot fucks right now that call themselves judges, could you get me the Supreme Court of Washington State? Because you decided to subscribe the oath of Brent Baisden, yes, when Governor Jay Inslee appointed him to a Superior Court judgeship right now. Now, there's this idea. You would always want to give notice to the respondent, informing them of the requirement, or it's at their discretion, right? But the obligation, right, that they should appear in court. Yes. You would want to give them the reasonable, timely, and proper number of days so that you, as a Superior Court judge, could tell them, well, you can motion the court and the court will review your motion as long as you get a mental health evaluation. Now, this idea of writing it in the protection order, Phyllis, yes, and then not having any notice, or myself having the opportunity to have to listen to Brent Baisden tell me what to do. Now, for every judge that thought, no, we don't want to talk to him, what we're going to do is we're going to write it in without actually speaking to the respondent. Yes. Now, on page 3 of 6, right. This idea will be allowed visitation as follows, right? No contact until there's a mental health evaluation, respondent, and treatment if recommended. Yes. And the court will review upon motion of respondent. Now, I would think, okay, that whenever a judge or a court commissioner has it available to them to speak to the respondent as the alleged perpetrator of domestic violence, that they would always want to make sure that the respondent gets notice and opportunity to be heard. So the respondent would have to listen to them, that they are telling the respondent, you may not contact the petitioner or the minors named until you've had a mental. Now, let's say, okay, it seems reasonable, right? I mean, what judge would want to issue a protection order? Yes. Where the respondent did not get any actual notice of the court hearing? Yes. It was not put in publication? Yes. There was no proof of service? Yes. And the respondent, yes, did not have the availability of actually seeing the petitioner at the court hearing, right? Because respondent never received actual notice of the hearing. Yes. Now, I've heard it as an excuse that judges, yes, don't like to tell the alleged perpetrators of domestic and child abuse, yes, that what they have to do if they want to be allowed contact with them. But I think it's really a negative. Now, if I were a judge in Washington State, oh wait, isn't that right? Forgeries? Oh, look at that. One for you and one for me. Ooch, look at that. The protected person didn't appear in court. Now, the petitioner didn't appear in court. Yes, but two different individuals appeared in court as the actual court officers. Yes. Now, we're having a problem because it seems like there is a moral and ethical obligation to myself, yes, my family, yes, and the community at large, that when you don't take your actual authority right now and inform the alleged violator of Washington state laws of their obligation to have a mental health evaluation and treatment if recommended, yes, that you've really, well, you've committed a crime. Oh, Pope. Now let's look through it. Okay. Phyllis? Yes. Now, since 2011, Brent Basden, the newly appointed Superior Court Judge of Clallam County, decided that he would issue a protection order, yes, without me being a resident of the state of Washington. Yes. Without an arrest taking place in the state. Yes. Without the actual residency necessary because Benjamin was born on Guam. Yes, he was. Now, since he wasn't there on Guam, yep, he has no idea what happened otherwise, other than there was just a written report that I had been arrested. That's right. Now, when I was going through the court hearings with Judge La Maurina, yes, you got a copy of the expungement order? The judge himself said, Mr. Budnick, I want you to do these parenting classes. And as soon as the judge told me what to do, within 3 weeks I'd gotten them done. Yes, he did. I went back and forth as fast as I could to get those parenting classes done because I wanted to be with my sons. Oh, now, when you don't have proof of service, yes, and when you don't have jurisdiction, and the court commissioner, Brent Basden, did not want to tell me what to do. I'm thinking I can sue this court, yes, for not obligating a court commissioner, yes, or a superior court judge to have to prove that I would have gotten the service of process so they could tell me what to do. Because it seems this court loves to tell people what the fuck to do.